Assalamualaikum and good morning to Dr. Muhammad Chin. Today I am pleased to present my personal portfolio on Malaysia industrial relations, focusing on two pivotal topics that shape our employment landscape. My name is Khairini Kasim and my ID student is 2021363539. The two topic is first, comparison of the Employment Act 1955 and the Sabah Labour Ordinance, and the second one is proposed changes to the Peraturan Pegawai Awam Kelakuan dan Tata Tertib 1993. Okay, here I will explain a little bit about Employment Act 1955. Employment Act 1995 is defined that the right and the obligation of employers and employers. It applies to most employers, establishing minimum terms on condition for employment, such as working hours, overtime, leave, entitlement, and termination procedures. However, it does not cover all workers. Specifically, it includes those in Sabah and Sarawak, where separate labour ordinance govern employment matter. Next is Sabah Labour Ordinance Cap 67 is the law that regulate employment conditions, workers' right and employer obligation specifically in Sabah, Malaysia. It is a guideline for contracts, wages, working hours and employee protection tailored to meet the local needs of the state. Even though we know that Sabah and Sarawak have their own labour ordinance, but they are still aligning with national labour standards where it is possible because they are still aim to harmonise some aspect of this ordinance with the Employment Act 1955, reflecting ongoing efforts to improve workers' rights and conditions in line with broader Malaysia labour policies. The first topic is the Employment Act 1955 versus the Sabah Labour Ordinance Sabah Cap 67, specifically regarding employment contract and unpaid compensation and benefit. The first article titled Tragic Death of Man Was First Change in Sabah Law on Paternity Leave, published on October 16, 2024. This article discussed how a tragic incident involving a worker who died while his wife was denied paternity leave due to inadequate regulation in Sabah has led to public outcry and calls for reform. And the second article is 33% of Sabah employers commit offences, say Sabah Labour Department highlight alarming non-compliance rate among employers regarding workers' benefits, particularly unpaid compensation. Okay, let's look at the issue employment contracts. According to report from the Sabah Labour Department, 33% of employees in Sabah have been found to violate labour laws in 2023. This is include failures to provide written contract to employees and not paying the minimum wage as stipulated by the law. Such violation not only harm workers but also reflect a lack of awareness among employers regarding their responsibilities under the law. In Sabah Labour Ordinance Cap 67 also mentioned in Section 4 and Section 12 about to protect workers in Sabah, including the rights to compensation and the benefits, and the regulates employment contract and mandate adherence to stipulated the terms. And next is comparison and contrast. When comparing the Employment Act 1955 and the Sabah Labour Ordinance, it's become evident that while the Employment Acts offer comprehensive protection for employees, the Sabah Labour Ordinance has no keep pace with this development. The Employment Acts provide extensive protection for workers in Peninsular Malaysia, including clear guidelines on maternity and paternity leave, unpaid wages, and termination procedure. In Sabah, Labour Ordinance has been criticised for its limited scope concerning employee rights and benefits. Although recent amendments aim to introduce provisions for paternity leave and reduce weekly working hours from 48 to 45, these changes are sufficient compared to the comprehensive protection offered by the Employment Act. The amendments to Sabah Labour Ordinance indicate an effort to align it more closely the Employment Act. However, significant gap in implementation and enforcement remains. Reports indicate that a substantial percentage of employees in Sabah are non-compliant with existing labor laws, leaving many workers without their rightful compensation. To push for reform highlight is growing recognition of the need for standardized benefits across regions as labor market evolve and employee expectation change. It is crucial that legislation keeps up with this development to provide adequate protection for all workers. The disparities between Peninsular Malaysia and Sabah underscore the necessity for a unified approach to labor laws that ensure equitable treatment for all employees regardless of their location. And next is topic B, the proposed changes to the Public Servant Conduct and Discipline Regulation 1993 are essential for addressing critical issues related to misconduct among public officers. According to recent article from Sinar Harian from January to August 2023, 804 officers from the Malaysia Police faced disciplinary action. This included 69 dismissals due to the misconduct such as corruption and abuse of power. These incidents have raised significant concern regarding governance standards within Malaysia's public sector. The Public Servant Conduct and Discipline Regulation 1993 govern the conduct of public officers. Regulation 4.2 states that officers must not behave in a manner that could be interpreted as disobedient or irresponsible. The legal issue discuss the proposed changes to the Sabah Labour Ordinance aim to address weakness in the current regulatory framework by introducing stricter measures against misconduct. These amendments are designed to modernize regulation, ensuring they are responsive to contemporary governance challenges. Key changes include clearer definition of the misconduct, enhanced reporting mechanism, and more robust disciplinary procedures for public officers. And next is comparison and contrast. The key difference between existing regulation and proposed changes lies in their approach to disciplinary measure. Current regulations have been criticized as outdated, lacking sufficient deterrent against misconduct. In contrast, proposed amendments aim to create a more robust framework that emphasizes accountability while providing clearer guidelines for handling disciplinary cases. This modernization effort reflects a broader trend toward enhancing governance standards within Malaysia public sector. By addressing existing gaps in accountability mechanism, this proposed change aim to restore public confidence in government institutions. And lastly, for the part B is the conclusion. The proposed changes to Malaysia Employment Act and the Public Officers Regulation aims to improve workers' protection and ensure fairness, especially in Sabah. These reforms are essential for addressing current challenges in the labour market. By strengthening this law, Malaysia can create a fairer workplace and build public trust in its institutions. And I'm very sure the comparison between the Employment Act 1955 and the Sabah Labour Ordinance Cap 67, along with the proposed changes to the Public Servant Conduct and Discipline Regulation 1993, highlight significant effort to enhance worker protection and government standard in Malaysia. And that's all from me. Thank you for your attention.